Welcome to Casa Academy, Chapter 6, Part 1, where we will cover violations of license law, penalties, and procedures.
Listen, you have worked incredibly hard to qualify for your real estate license. And, as you get ready to step out into the field, you carry a pretty heavy responsibility. The goal of this explainer today? It's to help you understand the rules well enough to avoid any disciplinary problems throughout your entire career. Now, while most licensees will never even come close to a disciplinary case, understanding how this whole system works absolutely protects you, it protects the public, and frankly, it protects that hard-earned professional license of yours.
Okay, let's dive into this. Here is our roadmap for today. We'll be looking at license law and penalties, fraud and misrepresentation, the disciplinary process, hearings and appeals, and finally, the Real Estate Recovery Fund.
Section 1, License Law and Penalties, the Avenues of Liability.
So, under Chapter 475 of the Florida statutes, there are three distinct ways a violation can come back to haunt you: administrative penalties, civil liability, and criminal charges. Now, it's absolutely crucial to remember that the Florida Real Estate Commission, or FREC, is not a court. They literally cannot put you in jail. However, really severe violations, think of a broker basically stealing a huge chunk of money from an escrow account and just disappearing, well, that can trigger all three of these consequences all at once. FREC revokes the license, the injured folks file civil lawsuits to get their money back, and criminal prosecutors step in to pursue theft charges.
While those criminal and civil matters go straight to the courts, FREC has its very own administrative enforcement toolkit. This whole shebang ranges from a simple reprimand, fines, and probation, all the way up to full-blown suspension, revocation, or just denying a license application entirely. But there's one really notable tool here, and that's the notice of noncompliance. This is specifically for relatively minor violations. If you get hit with one of these, you have 15 days to correct the problem without facing any formal disciplinary action. It's basically your chance to make things right before they escalate.
Of course, these administrative actions can also bleed over into the criminal side of things. A lot of criminal violations of Chapter 475 are classified as second-degree misdemeanors. That's definitely the most common. But if a violation happens to involve rental information lists or contract lists, boom, it escalates to a first-degree misdemeanor. And then we reach the most serious offenses, the third-degree felonies. This includes stuff like practicing real estate without a valid active license, putting fraudulent information on a state application, or, no way, stealing and reproducing a state licensing exam. Those escalate straight through the court system.
Section 2, Fraud and Misrepresentation, Defining Misconduct.
So, what kinds of misconduct actually get licensees into hot water in the first place? Well, consumers rely heavily on your statements when they're making massive financial decisions. Because of this, you should never, ever guess an answer if you don't actually know it. Just verify the information first. If you don't, you risk misrepresentation, which is making false statements or leaving out important facts. And right next door to that is concealment, which is intentionally hiding information. You have a strict duty to provide accurate, totally transparent information to your clients.
Moving right along, we have conspiracy and culpable negligence. Now, I want to clearly distinguish these two for you, because it's like a giant puzzle. Conspiracy is all about intentional teamwork, multiple people actively scheming and working together to commit fraud. Culpable negligence, on the flip side, doesn't necessarily require any malicious intent. It's more about reckless or careless conduct that ends up hurting others. So both are super serious for sure, but one is a deliberate, intentional scheme, while the other is just extreme carelessness.
And finally, for this section, we have conversion and failure to account. These two violations almost always center around the mishandling of money entrusted to a licensee. Conversion is the improper use of funds belonging to someone else, like, say, frequently dipping into escrow funds for your own use. Failure to account is exactly what it sounds like. A broker either cannot properly account for the money entrusted to them, or they simply fail to pay out funds that are legally owed. When it comes to money matters, you need absolute precision.
Section 3, the disciplinary process, life cycle of a complaint.
So what exactly happens if someone actually accuses a licensee of a violation? Well, the process usually kicks off when a member of the public files an allegation with the department. First up, a complaint analyst reviews it to see if it is legally sufficient. All that means is, if the allegations are true, the conduct would actually break the law. And this brilliantly illustrates the concept. Let's say someone complains that broker Bob painted his office blue. Well, that is not legally sufficient, because painting an office blue isn't illegal under Chapter 475. But if the complaint alleges broker Bob is employing unlicensed sales associates, that is legally sufficient, and the whole process moves forward.
Once a complaint is actually filed and deemed legally sufficient by that analyst, an investigator gets assigned to the case. This investigator goes out, gathers evidence, reviews records, and gets statements. And speaking of tracking important details, your verification code is 230011. Now keep in mind, the investigator is just there to gather facts. They absolutely do not decide guilt. After they finish the investigation, prosecutors review the file and pass their recommendations on to the probable cause panel. This panel, which is made up of 2 current or former FREC members, acts very much like a grand jury. They simply determine if there is enough solid evidence to move forward with formal proceedings. If there isn't, the case is dismissed.
Section 4. Hearings and Appeals. Resolving the case.
Okay, so what if probable cause is found? Well, an administrative complaint is officially filed against the licensee, who is now referred to as the respondent. From that very moment, they have exactly 21 days to submit an election of rights form. So the crucial point is this 21-day window where the respondent has to declare whether or not they dispute the facts of the case. If the respondent agrees with the facts, they head down the path of an informal hearing, which is held right before FREC. But if they dispute the facts, they go down the path of a formal hearing. That one resembles a full-blown court proceeding and is held before an administrative law judge.
Following that hearing, let's say it was formal, the administrative law judge issues what's called a recommended order. This contains findings of fact and conclusions of law, and it happens within 90 days. After that, the parties have exactly 15 days to file exceptions if they disagree. Next, it goes straight to FREC's final order panel, which, by the way, is made up of commissioners who were not on that initial probable cause panel, and they issue the final order. If the licensee still disagrees after all of that, they have a very strict 30-day window to file an appeal with the Florida District Court of Appeal.
Section 5. The Real Estate Recovery Fund, the safety net.
So, if a licensee causes real financial harm and gets penalized, who actually gets compensated? Well, that's where the recovery fund comes in. It's basically a safety net designed to compensate members of the public who suffer financial losses because of a licensee's misconduct. But there's a catch. They must first get a judgment against the licensee in court and prove that the judgment is uncollectible. When they finally do that, the maximum payout limit from the fund for a single judgment is exactly $50,000. So even if the poor consumer suffered, say, $100,000 in damages, the fund strictly caps out at $50,000 for that single case.
However, let's say you have a really bad acting broker who harms multiple different people. To put that into perspective, if 3 different consumers each manage to obtain qualifying judgments of $50,000, the fund will pay out a combined maximum limit of $150,000 against that same licensee. That $150,000 is the absolute aggregate ceiling, the total max they'll pay out for one person's bad behavior.
Now, you might be wondering, where exactly does all this safety net money even come from? Honestly, it's funded entirely by the fees that you and other licensees pay when renewing your active licenses. So, in a very real way, the profession is essentially insuring the public against the misconduct of its very own members.
Which brings us to our final takeaway. Listen, you don't need to memorize every single statute citation today, but you absolutely must recognize these violations and understand the heavy weight of the disciplinary process. As the course states perfectly, conduct business honestly, ethically, and in compliance with the law. Treat people fairly, carefully document your communications, and just follow the procedures. If you do this, you protect your clients and you protect your license. So as you prepare to enter this really exciting industry, ask yourself, are you going to be the kind of professional who merely memorizes the rules just to pass a test, or the one who builds a lasting, respected career by truly living them every single day?